Hi friends, welcome back. Let's talk about knowing your rights with CPS. This is Kara with the People's Harm Reduction Alliance and co-founder of the Harm Reduction Doula Collective. Knowing your rights with CPS. So this is one of the most common things that comes up when I'm working with my clients, my pregnant folks who use drugs, and rightfully so. So if you are a person who uses drugs or has used drugs and CPS gets notified that that they're to open a case or they're opening an investigation against you, it's really important that you know that you do not have to speak to CPS. I'm going to repeat myself. You do not have to speak to CPS. They will come. It's their responsibility to follow through with an investigation to see if there is any concern to the health and well-being of a child, given their practices and definitions of that. But whatever you say to them, they can use as evidence against you. It's like talking to the police. Whatever you say or do can be used against you in the proceedings of the child welfare state. This is why we super recommend, if it's available in your area, to get in touch with an attorney. We work with some incredible attorneys in the Western Washington area from First Legal Clinic, and they help our clients have legal representation all the way up to when the state opens a dependency case, which is the point at which the state is required to offer you legal counsel, so a public defender. And I say that it's important to get legal counsel prior to that because this is when CPS is building their case. They're collecting all of this evidence. They are trying to figure out whether or not they are going to take you to court for termination of your parental rights. During this time where the state is not obligated to provide you with legal counsel. We're also dealing with during this time setting up a FTDM, which stands for Family Team Decision Meeting. So if you have recently given birth, before you leave the hospital, usually in the first 3 days of your baby's life, you will be contacted by CPS to establish a FTDM. And usually they will put a hold on baby from being discharged from the hospital until they have completed that family team decision meeting. If you don't have legal counsel, or if you do, you and if you're parenting with somebody else will be asked to show up to this family team decision meeting. Usually they are super early in the morning. They're at 8 a.m. And it is really important when you enter that meeting to know that what the purpose of that meeting is coming up with a care plan for your child moving forward from hospital discharge. And you can kind of see it like a plea bargaining or a mediation, a court mediation. They're setting the terms and the requirements either for which you get to have your baby stay in your custody. So that could be that you need to have a certain number of check-ins, or you need to have round-the-clock supervision, that you're going to attend random UAs, or that you need to be enrolled in a treatment program. Whatever those requirements are, they're going to work to establish an FTDM, or they're going to say, based on what we know about this situation and your history, we are not going to let baby go home with you, and here's all of the steps that you need to take in order to regain custody. So this is super important. It is so I'm gonna be careful with my words. I'm just gonna say it's messed up, because essentially you're getting put into a contract, an obligation with the child welfare system, and they're not even letting you know that you might need legal counsel. And so if you don't have legal counsel in your area, I want you to not lose hope. There's a lot of other tools that I'm going to talk about in this video that can be super, super supportive. So having family members present is not a closed meeting. having family members come and testify on your behalf, having friends come and testify on your behalf, having anyone that's in your family or support network constellation come and sit in on that meeting as a support person is hugely powerful, because it shows CPS that you have people that are in your corner, that are watching out for you, that are going to support you, that are going to support this baby, and they don't feel scared that you're going to take baby back to wherever you're living, and something bad is going to happen because nobody's watching or nobody's there to support you. They are gonna look for, have you had prenatal care? How much prenatal care have you had? Are you showing up to the doctor? They're going to have that as a record, and they count it against you if you do not have what they deem as an adequate amount of prenatal care. They're going to see, like, do you have other children in the system? Unfortunately, this is usually used as a count against you, but I want to again restore hope, because we have had clients who have had other children in the system, and a lot of times the requirements for getting another child back are going to be the same requirements that they have for this baby. So if we can get in as much support around you during this time, and we can get a plan that CPS is willing to agree to that also works for you, there's a good chance that we can move towards you regaining custody of your children, plural. The caveat to that is that I like to say that CPS is like tree fort rules. So that means that sometimes they're benchmark shifts, sometimes they have a rule and then that rule gets added to or kind of changed. And so it's really important to document and ask for a copy of your safety plan. It's really important to make sure that you have witnesses that have been there to know what you've agreed to, that are signed on to your safety plan, that when they're asking for updates, that person can also be on the email thread so that they can see, like, oh, like, wait, hold on, like, that's not what we agreed to when we were in that FTDM. They can't change the safety plan after the safety plan is already in place. However, if you have a child that is in CPS custody in another county, each county has their own rules and their own set of guidelines. It makes absolutely no sense. It doesn't like follow any sort of logic to me that it wouldn't be on like a state level or a national level that we follow certain criteria all the way across the board for the child welfare system. But not every office of CPS is going to handle things exactly the same, not every caseworker, and on like a policy level, not every county is going to handle a CPS case in the same way. That being said, having a safety plan that you can have people in your corner advocating with you for reasonable requirements, reasonable accommodations, is super important to showing CPS like that you're able to meet these requirements, and have people that are going to be there to help you meet these requirements, to hold them accountable to like that agreement, but also to show other departments, if you're working with another department, that you have been sticking to a safety plan, and see if they might be able to honor some of those steps that you've taken also in that other custody case. Part of knowing your rights with CPS is that they are supposed to provide you with resources. A lot of people don't know this, and it can be really like hard to ask, or there might be a feeling of like, oh, if I ask for this, are they going to count it against me? So it really doesn't hurt to ask, and if they don't deliver on it, then they're not upholding their end of the deal. Things like laundry vouchers, they can't fault you for having, not having clean clothes if they're not willing to help you access the means that you need to do that. I've heard of CPS like actually, when they're doing their job, buying a washing machine for somebody. They're supposed to help you with transportation, whether that's bus vouchers. I mean, it would be great if they had like, Uber vouchers. They're not usually that generous, but they're supposed to help provide you with transportation. So say your child gets placed out of care and they put you on supervised visitation. So that means that you would have to go have visitations at a family visitation center, and they usually schedule them, and you have a certain window of time that you have to get there in order to visit with your child, and then the visitation session will be over and you'll leave. They're not always very close by. So not only is it reasonable to ask CPS to help you with those accommodations to get to and from, because it's not, your fault that you might be quite far away, but it also helps to document if that's like in an email, or if, you have that in your safety plan, that you were making reasonable efforts to ensure that you got to visitation. You weren't just not coming to your visitation, or you weren't late to your visitation because you just weren't taking it seriously, but because you didn't have the means to have adequate transportation to meet their criteria that they were putting on you. Always good to have a backup plan. That only goes so far, especially in the eyes of the court, but I can't stress enough how much documentation matters, and also holding CPS to their better angels if they're going to hold you to your better angels, okay? You have a right, whether or not you want to confide in that social worker that CPS provides you. I've heard numerous times these misgivings that somebody from CPS showed up and said that they were a social worker. They were there to offer resources and basically asked you to pour your heart out and share your story. And then they ghosted, or they just reported those things to their higher ups, and that was used against you. Not every CPS caseworker is the same. So I want to really stress that sometimes you can get a CPS worker that's really trying to hustle and get you resources, but ultimately at the end of the day, they do work for the child welfare system. It is whatever they say can get reported back, and ultimately can be used to collect evidence on you. So making sure that you're leaning into your intuition, you're trusting your judgment, you are sharing the pieces that you feel are relevant and help and support your ultimate goals is super important. You also have the right to explore where your child is placed. So if your child is placed out of care, you have the right to try to seek out family members that can take baby. So just because they decide that baby is not allowed to stay in your custody doesn't mean that that baby should go directly into a foster home of an unknown care provider. Do you have a family friend? Do you have family members? Do you have close friends that you trust? Who's in your network that you trust to be an ally and an accomplice with you in this journey to reunification? Who your baby gets placed with can make a huge difference, not just for the health and well-being of your baby, but also your own health and well-being, your own reassurance, and knowing that that person is on your side and sharing a goal, that they're just stepping in to provide a temporary role, a temporary care position to love your baby when you can't be there. It can be so healing and reassuring, even if it's painful at the time. You have a right to be a part of that process and to try to seek solutions. I'm going to give an extra special highlight to the Indian Child Welfare Act. It's called ICWA. So if you are eligible for tribal enrollment, it doesn't matter if you are enrolled or if you are not enrolled, the CPS system has to uphold ICWA. And ICWA is a series of legal guidelines about how the care and placement of Native children, Native American and Alaskan Native children, are handled in this country. So if a child is eligible for tribal enrollment, CPS is mandated to let that tribe know that there is an open case. And a CPS representative from that tribe is supposed to take over. If they do move to go to an external placement, then that baby has to be offered, or that child has to be, a placement needs to be explored with members of the immediate family. If there's no members of the immediate family that are eligible to receive placement for that child, then it's going to be a member of any enrolled tribal member within that child's First Nation affiliation. If there is no person eligible within the First Nation, then that placement goes to any Native person. And then if no Native person is available to take this baby, then it goes to any person in the foster system. So this ensures that culturally congruent care is being provided to this child, that they aren't being ripped away from their culture, from their lineages, from their traditions, from their like care networks, to be placed with a family that is not Native. And this comes out of a long legacy of overrepresentation of Native children in the child welfare system. I'm not going to go extremely deep into it today. It's a horrible and often like really traumatizing history, but it's important to know about that, you know, 1 in 4 children who are Indigenous are in contact or have CPS intervention in their lifetime. And so it's super, super important to know your rights and to make sure that the department is upholding their ICWA responsibilities. Again, any family, any person interacting with CPS has a right to explore options for where their child is placed. If you get moved to a dependency case, you have the right to a public defender. And so making sure that you are being given this information, making sure that you are being provided with an attorney is super important, and really, really, I can't stress enough, like, your human right. Like, we have a constitution and a right to a fair trial for a reason. And a lot of the way that the system works is very unfair, but there are little things that, you know, can make a huge difference. And having representation and having people in your support network knowing your rights and letting them know and documenting everything goes a super long way. We can't always control the outcome, and that is really scary and really hard, but we can use the tools in our toolkit to advocate for ourselves and to make sure that they're following the steps that they're meant to be following, and they're upholding their end of the responsibility. Thank you for being here today. I love you. Keep being you. And we will talk to you soon.